Welcome to Concepts in 3 Minutes or Less. In this video, we'll be looking at legal issues. This is a big topic, so I've had to break it in two. You'll find the main reference to this in the Applied Computing Study Design, page 44, under Unit 4 Outcome 2. Reference to the legislation also appears elsewhere. This timeline shows when relevant Acts of Parliament were legislated. All of them refer to protecting data, including copyright. And notice how much legislation has been written in just the last 2 decades. It will come as no surprise that data legislation is accelerating, and society's move to artificial intelligence will only add to this pressure. This is exemplified by things like the recent amendments to the Privacy Act to cover modern issues. Lastly, note the existence of the privacy principles, which are part of the legal document and an attempt to crystallize the meaning of the law. The cover page of an act identifies it very precisely. Quoting the year is vital. The bulk of any Act of Parliament attempts to cover every contingency, flaw and argument. When something is missed, however, judges have the ability to set a precedent to address this. Orders made resulting from a legal contest also become law. This is what makes them so hard for the average person to understand. Hence the Australian privacy principles. There are 5 groups and they are all about personal information. You must be told how it is collected and used, you have the right to access and correct it, and you have the right to have it kept safe. The quote, "Data is the new gold," fits very well here. Broadly, they describe the collection, use and disposal of data. Take special note of number 9, use of government IDs. Identifiers such as tax file numbers can link database records across multiple databases and thus must be treated very carefully. The health privacy principles are very similar. They are embodied in the Victorian Health Records Act 2001 and their primary purpose is about health information. Note that this is a Victorian Act of Parliament, not a federal one. The health privacy principles share much with the APP, but there is a sense of greater rigour around the health data because it could prejudice obtaining insurance, getting a job, or acceptance in some social settings. Above all, it is highly personal and may cause unnecessary embarrassment if not kept securely by highly trusted members of society. There needs to be extra provision also in life-threatening situations, e.g. consent. Most of the health privacy principles are in common, but there is a special provision in the last 2. Transfer also sets the rules in the event of the closure or change of ownership of a health practice. The sharing clause, number 11, allows for medical data to be shared across health providers such as your doctor, specialist and radiographer. I certainly hope that was helpful. Thanks for watching and keep an eye out for more over the coming weeks.